You'll notice I'm the only one here from before. Judge Eisnagel to my right, Judge Harris to my left. And we have our last case, which is Amber ZEEFF versus ASHTYN PETTIT, I guess. So whenever y'all are ready. And let me know if you need anything other than 5 minutes for your rebuttal. If you're not familiar with our lights, green, you're still good. Yellow, you're into your rebuttal. Red, when I'm here, it's time to sit down and stop. Okay?
Yes, Your Honor.
All right, thank you.
Good morning. May it please the court. My name is Amber Hiltzbrand on behalf of the appellant Amber ZEEFF, and 5 minutes is sufficient for the rebuttal. Thank you. We are here on an injunction for protection against stalking. It's based around the issues of cyber stalking because it dealt with electronic communication. Our argument is that the trial court erred in granting the injunction because it did not meet the legal requirement, excuse me, for the stalking injunction. Looking at the statute, stalking requires willful, malicious, and repeated conduct, such as cyber stalking. Cyber stalking, of course, is electronic communication directed at a specific person, causing substantial emotional distress and serving no legitimate purpose. Our argument is essentially threefold. The first one is there was no malice on behalf of the respondent, Ms. ZEEFF. The second is that the communications would not cause a reasonable person substantial emotional distress. And the third is there was legitimate purpose for the contact. Going first into our first argument that there was no malice, again, there's no evidence that the communications from Ms. ZEEFF to Ms. Pettit were malicious. And I'm sure your honors are aware, but just to reiterate the little bit of the background, is Ms. ZEEFF is the biological mother to Ms. Pettit, who she then gave up for adoption to her own parents. So she in turn became her sister, to make it sounds a little wonky.
Well, throughout the testimony and the text messages, she refers to herself as, at various times, sister or mother, and sometimes sister/mother, correct?
That is correct. That is correct.
So the relationship isn't just one of sister. It seems to be, in some way, both.
Yeah, yes, Your Honor, and that's how our client interpreted it as well, as they still had that familial relationship regardless if it was biological mother or sister, because they're still in the same family.
Certainly a familial,
yes.
A family relationship, yes.
Yes.
Do family members have greater right to disturb, stalk, whatever word you want to use, their co-family members than strangers do?
Honestly, Your Honor, reading the case law, it doesn't really differentiate, but again, that goes to there was legitimate purpose for the conduct, because...
Whose mind?
I'm sorry?
In whose mind was there a legitimate reason for contact?
The respondents, Ms. ZEEFF's.
Right. Well, I would think often the person who's accused of stalking thinks there's a real good reason. If only he or she who I'm pursuing would just stop and listen to me, I could convince them that we should have a good relationship, which is basically what your client was saying here. If you'll just stop and talk to me, we can work everything out.
Yep.
That's a common thread, I would think, through almost every cyber stalking kind of case.
Well, Your Honor, based on the case law, it is our argument that other courts have upheld that there is a legitimate purpose for conduct when there's no other intent other than to harass. And it's our contention that the communications were not harassment in any way, shape, or form. So that's where
your client was told very clearly that the petitioner did not want to hear from your client, correct?
That is correct.
And your client nevertheless sent communications, correct?
She did, Your Honor, and again, that still ties into our legitimate purpose, because up until, I believe, around August of 2016, as the testimony indicated, they had a relationship. They spoke, they saw each other, everything was very, very
But then at that point,
cordial.
the petitioner turned 18.
Yes.
And made a decision that she did not want to have any relationship with your client, correct?
That is correct. And then the reason for the contact in August of 2016 after Ms. ZEEFF received that video indicating that communication was for the fact this was the first time she heard it, and any reasonable person, even a family member in that same situation, still would have reached out to say, where is this coming from? I'm not sure what I did. You know, she wants to try to fix it.
What about the communications after that?
After that, it was approximately 2 years later, in August of 2018. Yes, sorry, I almost said 2018. It was my client had left a positive Facebook review. She received a message from Miss Pettit on Instagram saying, leave me alone. And she still initiated with the same, basically, I don't know where this is coming from. You know, it was her intention that it's been 2 years, enough time had passed.
At that point, she had been told twice that she didn't want to have, that the petitioner did not want to have any communication with your client, correct?
That is correct.
And yet your client nevertheless sent multiple messages.
That is correct. But then
At what point does it become, you know, illegitimate, right? You have an adult woman saying, I don't want to have anything to do with you, right? Not you, but your client.
Yes.
I think we all agree that that's clearly the evidence. How long can your client continue to send messages before it becomes illegitimate? Or can your client forever, for the next, 50 years, send unwanted messages because they're family or whatever else?
Yes, Your Honor. So we did cite two case laws. The first one was Branson because he had sent approximately 300 emails in a month and a half. So the court did find that that was stalking. We differentiate it here because there's only a total of 4 messages. There was no indication that she was going to continue to keep contacting her because after the last communication, I believe was on or about August 10th or 11th, there was no further communication. It was approximately 7 days after that she wasn't even served with the
One
injunction.
communication, which communication said we will see each other soon? Which one was that?
I apologize, Your Honor. I don't know off the top of my head.
I mean, that seems to indicate it's not over, doesn't it?
Well, that they're
You agree that there was a message that said that, right?
I do not recall that, Your Honor, and I do apologize. If it's in the record, then I can't deny that she didn't say that, but I do not recall that off the top of my head. But even
If she did say that, let's assume for a moment that's in the record. That would certainly indicate it's not over, wouldn't it?
well, it's also because of the relationship. They're still part of the family. They still go to family functions together. They still have Christmases, Thanksgiving, things like that
Here's what the
together.
message says. It's on page 60 of the record. And I will do anything for you, but your anger has gone too far. True godly people do not thrive on anger, my love. We forgive and move on because life is too darn short. I wish you the best, and we will see each other soon. Be an adult and move on. So that's what one of the messages says. Doesn't that indicate, hey, it's not over? We're going to see each other and continue to have interaction?
I think that's basically because of the relationship. I think it would be a different story if they didn't have that familiar
I was just
relationship.
responding to your sort of statement that, hey, like, look, it was over, there was no indication that it was going to continue, and wouldn't you concede that's at least one indication that it might continue?
Yes, Your Honor.
Okay.
I could. But again, we obviously can only base it off of the communications that were presented, and our argument is there were 4 communications total, 1 in 2016 and then 3 total in 2018. And then just overall, and again, based on our brief and based on the case law that we presented, I believe it was the 2nd DCA quoted in Carter, 4th DCA case, that they've held that limited actions would not cause a reasonable person substantial emotional distress. I apologize, I'm like jumping around a little bit, but again, it's because of the limited extent and the involvement, again, because that's what makes our argument threefold.
Well, counsel, if we look at, there's 2 different ways to look at, I think, the messages here, right? I mean, if we just look at the message and we isolate the message, I think you have a strong argument then that, these messages in isolation would not reasonably cause emotional distress. But is that how we should review this? I mean, or should we review it in the entire context of all the testimony and everything that was happening?
Our interpretation is based on the case law. It is a reasonable person standard that's narrowly construed. So
not in the context?
it would be, you have to look at the communications, and based on the communications, whether those communications alone would cause.
Just the communication.
Just the communications. That is our interpretation.
No matter what the context or the prior relationship between the parties?
Correct, because looking at the other case law, it seems that's how they interpret it as well. They looked at voicemails, emails, text messages, letters, and they looked at the context of those messages alone. Of course, there is the background that goes into it, but in the rulings other courts have made, they've stated specifically those communications would not cause a reasonable person substantial emotional distress.
And your reading of the case law is that you read those in isolation, you don't consider the context.
In terms of just the
You read the messages in isolation to determine whether a reasonable person would suffer emotional distress.
That is our argument.
What case
yes.
says that, though?
It doesn't state it specifically that they only look at the messages, but looking through everything, even they do talk about the background, but then all of the holdings specifically state the emails.
Let me ask you this,
themselves.
counsel. So there's a message that says, "I'll be there in 10 minutes." If we look at that in isolation, there's no way that could cause emotional distress, right? I'll be there in 10 minutes.
Correct.
What if it is from someone who had a relationship with the recipient of the message that was very violent in the past and had involved multiple threats, and in fact, in the past, the person had shown up at their house and beat them up. And then this person who has been beat up many times gets this message, "I'll be there in 10 minutes." Doesn't that make it seem a lot more reasonable to be emotionally distressed?
It does, Your Honor, but again, our argument is it's just even when you take into the context of everything, the messages themselves shouldn't cause a reasonable person substantial emotional distress. Given the relationship, there was no domestic violence, there was no physical form of stalking, everything was quote-unquote cyber stalking.
Stalking doesn't require a physical form of stalking, right? I mean,
correct, yes, it was just to kind of delineate our argument. We're just focused on the cyber stalking and not any other form of stalking. So it is different than a person who has been physically abused, and again, over the amount of time, there's only 4 messages.
well, it's a different type of injunction, yes, but what I was talking about, shouldn't we view the messages in context?
Even if you did, Your Honor, just looking at them, we would still argue they would not cause a reasonable person substantial emotional distress. Everything that was presented into evidence, and I believe the trial court judge had stated something along the lines of, "I can see she's in distress." Our argument is that was actually a subjective standard, because looking at the petitioner, her demeanor, her appearance, her behavior, that is purely subjective.
Grandmother testified, right?
Yes.
When I read her testimony, it seemed to me, now, unfortunately, we don't have the benefit of actually seeing the witnesses. The trial court does, and that's why we give the trial court great deference on these things. But when you just read the grandmother's testimony, it certainly sounds like she was of the view that your client was engaging in actions that caused distress for everyone. And I think she even essentially said that everyone was frustrated with your client and couldn't understand what was happening.
And given that, my client did testify that the reason why she'd reached out the second time was because her family was the one that actually brought it up. So we obviously, not to bring it up now, but we did have issues with the grandmother's testimony. But even then, she testified to her behavior and things along those lines, which again, we would argue would be subjective and not that reasonable person standard.
But now you're sort of asking an appellate court to second guess the trial court when the trial court heard from 2 witnesses, right? Who characterized your client's actions as essentially over the line and causing everyone to be frustrated.
But even then, frustration still isn't enough to grant an injunction, and that's where it comes in. It's, that's why our argument is threefold. If you look at it, a reasonable person would not have reacted.
Well, grandmother was frustrated, but grandmother doesn't need to suffer emotional distress. Only the petitioner needs to suffer emotional distress, correct?
That is correct.
Right.
That is
so
correct.
when the grandmother characterizes it as frustrating for everyone, that doesn't necessarily hurt the petitioner's case. They don't need to prove that grandmother would suffer emotional distress.
Right, right. But even if petitioner said that she was frustrated, that's still not enough for the substantial emotional distress. And again, even looking at the other case laws, the messages themselves, they weren't hostile, they weren't violent, they weren't threatening. And
Wasn't the evidence was conflicting, right? That that your client continually created new accounts in order to try to friend or follow the petitioner?
that's what the petitioner testified to. The evidence that was presented were of the blocked accounts. And I don't know how familiar you guys are with social media, but if I were to get on my Facebook page and, Your Honor, look up your profile, I can essentially block you without you having friend requested me. So that's where our argument came in. Other than the testimony, there was nothing stating that she had friend requested her, and even so, if she...
Why is her testimony not sufficient?
That's just our position, that it wasn't competent or substantial enough to show that there was a friend request, and even if there were friend requests, it's not a form of communication that would fall under
Well, no,
the
I was
statute.
asking you about the creation after being blocked. The testimony was, petitioner said, look, I kept blocking her accounts. She kept reaching out to me, I kept blocking her accounts, but then she would go and create a new account so that she could just keep sending me friend requests. That was petitioner's testimony, correct?
That was her testimony, and my client's testimony was that her name had only changed because she's
Right.
been married, I
Your
believe.
petitioner said that happened. Your client said no, it didn't.
Yes,
Conflict in the evidence,
yes.
and the trial court decided that it believed the petitioner.
I would
Potentially,
assume
right?
so since they granted the injunction, but I don't know how much that was taken into the consideration for the injunction. And part of our argument would be, too, that even if there were those, I believe, 8 to 9 friend requests, it's not a form of communication as defined under the statute.
Does it contribute to the context of what were communications later on? I'm not suggesting that a friend request is a communication. I'm suggesting that perhaps it contributes to the context.
I would say no, just because the messages were separate, and again, those messages were with the intent of, one was response to a video. The second one, 2 years later, hey, enough time had passed, I thought maybe we could mend that relationship, and that's where those 3 messages ensued.
Do you want to save the rest of your time for rebuttal?
Yes, please, thank you.
Good morning. Excuse me. My name is Lauren Heatwall. I'm here on behalf of the appellee, ASHTYN Pettit. May it please the court. To answer Judge Eisnagel's concern, I do believe that it's the totality of the circumstance that this court should be considering. Look at the case law cited in both counsel's briefs, we use a lot of the same cases. It's a matter of interpretation. All of the cases look at the totality of the circumstance in injunction cases, specifically stalking injunction cases, and particularly dealing with cyber stalking within that subset. The Branson case, which was initially cited by Counsel Hilterbaum, talks about 300 emails. Counsel also refers that as far as trying to compel this court to see that our case, the instant case, only has 4 specific written communications, not counting the Facebook friends, not counting the messages through the parents, not counting the following, not counting the positive review that was left, but just narrowly looking at the 4 main long messages that were sent to my client after 3 times being told not to.
Don't you agree, though, that those are the only ones that would qualify?
Absolutely.
Okay.
Right. The only 4.
And this isn't the most extreme case, right? We don't have 300 messages here.
No, Your Honor, we don't, but we don't need 300. All we need is 2. And in fact, we have 4 in this case that were presented in evidence, both via testimony as well as documentary backup evidence. The case law is clear, and as outlined in our brief, Ferris case indicates that testimony is, of course, evidence and can be considered by the trial court, which the trial court did. We're here based upon Judge Brewer's consideration of all the facts, all of the evidence from both parties' testimony, as well as both parties presenting documentary backup evidence. Petitioner, which is now appellee,
Counsel, but when we, and I think that, the other side makes this point. When you read these messages, I mean, there's no overt threats in them. There's no, vulgar language in them. When you read the messages, I mean, it's hard to imagine, if you're just looking at the messages, it's hard to imagine a reasonable person suffering emotional distress from them.
Respectfully, I disagree for two reasons. One, the Branson court says that threats are not required. The Branson court looked at those 300 emails and, again, only needing 2, determined whether or not a threat was at issue. The issue in Branson was not about the volume or the number of the email messages. It was about whether a threat in those messages were required, and the answer was no. In this case, secondly, Your Honor, is that the context of the situation, those emails are such that there's no legitimate purpose and it causes reasonable harm. Even if you look at them in isolation, even in the context which is required.
Well, fair enough, but point me to the statement in the messages that you would say, if we're only looking at the messages, that a reasonable person would suffer from substantial emotional distress.
Being told that such person is being controlled by Satan, that was a recurring theme in at least 3 of the messages, that person, the recipient, was being controlled by Satan. They needed to grow up. They needed to be an adult. They needed to see the person telling her, "I love you, my beautiful." I mean, it's often reminiscent of, the fairy tales with a wicked godmother saying, "I love you, my pretty."
Well, we have a family relationship here. Saying "I love you" between family members. Again, if you just look at it in isolation, it would be hard to write an opinion saying that a reasonable person would suffer emotional distress from that.
True, only if the email was only, "I love you, my daughter/sister," and it ended. That was not the case in any of these 4 messages. These 4 messages were paragraphs long, going into extensive detail of the appellant's mindset as to why she was trying to convince the appellee to have a relationship with her. The appellee had made clear.
Go back to one of Judge Edwards' questions earlier. Is the standard different, at least if we're looking at legitimate purpose, the fact that there is a family relationship?
No. There is not one case that I found that says that because there is a family relationship, there is a lesser standard for folks to follow. In fact, it's all based upon.
Case written by this guy next to me here. Both messages serve legitimate purposes, given that there was a family relationship.
I'm not sure which case that's recited to, but in the context of what's the underlying relationship, it's not just simply.
Mother-daughter.
I'm sorry?
Mother-daughter, or adoptive mother-daughter was in this case. It's Lippens v. Powers is the case I'm looking at here.
Yes, Your Honor. I'm sorry, go ahead.
Are you saying there could never be because of a family relationship, there could never be if someone tells you, I don't ever want to hear from you again, there can never be, after that point, a legitimate purpose to contact them?
No, I'm certainly not taking it to the extreme. The Lippens case was a marital relationship. 2 women, same-sex women, had a child. One mother, the wife, became estranged. The case calls her the estranged wife. She tried to reach out to the minor child, which is a key point, minor child. And in that opinion, it states that the evidence presented, there was no evidence as to whether the estranged mother had visitation rights to the child, such that it was legitimate that she was trying to contact the adult, the guardian of the child, for visitation. Also notably, the estranged wife, the mother, when contacting the other parent to try to have contact with the minor child, said, "I will defer to the child's wishes." What's different here is that we have 2 adults. Yes, they are related as a family by blood. However, 2 adults who have the opinions and abilities to make their own choices. The Lippens case involved a minor child. That's completely different. In this case, the testimony at trial showed that the parties, the appellant and the appellee, although related by blood, do not own a business. They do not have a minor child. They don't own real property together. The other cases that talk about legitimate purpose talk about some other fact that connects these parties, perhaps because they are related as a family unit, but some other purpose that requires them to communicate for a greater good. In this case, there's no greater good. There is no tie. The evidence showed at trial that they had separate family functions. The mother, and just a correction to the court, it was actually the mother who was testifying, not the grandmother, and she was the mother to both the parties. She was the birth mother to the appellant, and she was the adopted mother to the appellee. And she and her daughter, the appellee, testified that family functions were held separately. So there is no reason that these two adults, in this case, have to interact with each other. So respectfully, I don't believe that Lippens
The
governs.
appellant didn't want to give up, and she wanted to have some type of a relationship. Where is the evidence that that was done with malice?
Malice is not required, Your Honor. Competent and substantial evidence, and when you define cyberstalking, cyberstalking does not require malice. Maliciousness does not require ill or mean intent. And that is from the brief cited in regard to Standard Jury Instructions 2012-5. Rather,
So you would agree that there was no malice in this case?
I can't agree to that. There was no evidence presented that I could form an opinion. I will admit that the appellant testified that she was trying to do it for a family purpose because she was trying to do it to have a relationship with her birth daughter. The court can read into that what it wishes, however, it's irrelevant, respectfully.
But the statute says you commit stalking by maliciously cyberstalking someone.
Correct, and malicious is defined as no legitimate purpose. So it brings us back to the circle where, is there a legitimate purpose? There's no legitimate purpose except the only argument that appellant is making is that they are related by blood. Thus, she should have the ability to have a relationship with the appellee, even though the appellee has expressed herself clearly, specifically to the appellant on at least 3 occasions that are in the record. I do not want to have a relationship with you. If you persist, I'm going to file a restraining order. And going back to Your Honor's point about how the individual messages could be construed, the appellant also stated in the message responding to the appellee's request to leave her alone or she'll file a restraining order, she said, "Don't threaten me." So in essence, the appellant was saying, you better not do this or else, which on the face of the message in that long paragraphs is absolutely emotionally distressing to anyone who might read it, much less in the context of the totality of the
So
circumstances.
do you agree with your opposing counsel that we should only consider the messages in isolation and that we should not consider the context in which the messages were sent?
I wholeheartedly disagree.
Okay.
I believe that it's the totality of the circumstances, and I think that the case law dictates that.
You're saying that even if you looked at them in isolation, you still think that there'd be enough?
Correct. Correct. I also think that the totality of the circumstances was recently exemplified in this court's case dated June 28th of this year, Betancourt versus Leon. Here the court affirmed that the trial court in a DV injunction case properly considered both sides' testimony and the historical information. I think that is a recent case the court in a stalking situation evaluates the whole circumstance, the totality of the circumstances. In this case, the totality of the circumstance is a 20-year-old college student who has expressed herself when she turned 18 that she does not want to have a relationship with her birth mother. And despite her respectful and clear messages, the appellant persists in sending these messages. The statute requires that we have 2 instances of stalking, and in fact, we have 4. Counsel for the appellant admits that we have 4 clear messages. She admits that 3 of those were after being told by the appellee to leave her alone. There's no legitimate purpose that these messages serve. I don't believe...
Is one of the messages the positive Facebook review?
No, Your Honor.
Okay.
It is
You're talking
not.
about the communications that occurred after that.
Say that again?
You're talking about the 3 that occurred after that.
Correct. There was the first one in 2016, then 2 years later on August 10, there was a positive Facebook review, which prompted the appellee to say, "Leave me alone," and then that was the second "leave me alone," and then that prompted the 3 responses, the 3 instances of stalking on August 10, 2018. So we are not counting the positive memo. I think that the point was also made that the mother is a reasonable person testifying on behalf of the appellee, to say that the appellant's actions had offended not only herself as both of their mothers, but also the rest of the family, and that members of the family had attempted to get the appellant to stop harassing and cyber-stalking the appellee. I think that in and of itself is sufficient, even if the court were to only look at the petitioner, which is the appellee. It's clear from Judge Brewer's that she was under emotional distress, both by her visibility and how she was acting.
But that's not really the test, right? It has to be reasonable.
Certainly.
Right?
Absolutely. My point, Your Honor, is that as we unravel the layers, we start with the narrowest approach, which is the petitioner, the appellee. She clearly was under emotional distress. I don't think that that's a question mark. If you expand the scope to the next reasonable person, we have a witness at the test trial, which was both of the parties' mother, who testified on behalf of herself and indicated that other family members thought that the cyber stalking was inappropriate, that it was unwarranted, and that it was causing emotional distress. If you look beyond the layers of that and expand it to a larger scope, I think both on the face of the messages themselves, it's clear that any reasonable person in the appellant's position would endure emotional distress. And if you take it one step further, which is actually what this court, I believe, is bound to in the totality of the circumstances, you look at the entire environment, which include the other instances, although not warranted or not rising to the level of an actual incident of stalking. You have the multiple 9 accounts that were created or recreated or redefined through her name, through the appellant's change of names. You have the fact that there was a positive review. You have the fact that she was trying to find the appellee's sorority, which was testified at University of Central Florida. You have the bigger picture that there were messages being sent through the family. So when you look at the totality of the circumstance, it's clear that there was emotional distress, and that any 20-year-old in school going through this situation, to have a birth mother come after her multiple times after asking her to stop and warning her that she was going to seek injunctive relief, to have that persist, I think the court clearly can find that Judge Brewer, in his discretion, determined that the evidence was legally sufficient. I think this court can find that the evidence was legally sufficient and should affirm the trial court's final judgment.
I'm a little bit concerned with the malice element. Where in the statute does it say malice means something other than malice?
Malice is not defined in the statute. In interpretation of the statute, malice looks at what is maliciousness. To my knowledge, there's nothing that says maliceness requires ill or mean intent. It is without legitimate purpose. If there is a legitimate purpose...
Is there a case that says that?
I'm not aware of any at this time, Your Honor, other than the standard jury instructions of how to define malice.
The standard jury instructions in what context?
Those were in criminal cases.
Stalking?
Yes, in a criminal case for stalking, of how to define stalking and how to define cyber stalking, when you are trying to narrow down the definitions of the words in the statutes, then that is where I pulled that information, and it's cited in the appellee's brief. So when you're looking at maliciousness does not require mean intent. It requires no legitimate purpose. But hypothetically, even if it did require ill intent, which I don't believe that it does, the court can interpret that the appellant still had ill intent because by virtue of her persisting after being told not to. If she was truly trying to respect her birth daughter's wishes and trying to respect the situation in which trying to bridge the gap and have a family relationship over time, she should be doing it with a heart of love. And she wasn't doing that. She was doing it selfishly of ill intent. So I think even if you take it to the extreme, Your Honor, and don't look at the definition and the context of maliciousness, I think the facts are still there because the competent and substantial evidence, and another interpretation of that, is what's adequate. Did Judge Brewer adequately find, based upon competent and substantial evidence, that there was at least 2 instances of stalking, in this case cyber stalking, that caused reasonable emotional distress and without a legitimate purpose?
Push your case for a moment. So is there evidence of, if malice means hate, and I'm not saying that it does, but if it does, let's say for a moment it does, then do we have to reverse this? Or was there evidence of some level of hatred or, ill will?
No, you don't have to reverse it. And yes, there was evidence of ill will, or I'm not sure if I should use the word hatred, but animosity. Again, going back to the context of those messages, I think any reasonable person reading those messages being accused of being controlled by Satan, I think that a reasonable interpretation of that could be that someone has ill intent or has a negative frame of mind to be putting my opinions on that person. Also, and as I mentioned, I think that if the appellant's real intent was to have a relationship with her birth daughter, then doing it in a way that respected the wishes of the recipient, respected the wishes of the appellee. When she kept doing it after being requested not to, she goes into the path of ill intent.
Any other questions?
Okay. Thank you. I think that this court clearly can find that Judge Brewer, in his discretion, evaluated the evidence, that it was competent and substantial to meet the statutory requirements for at least 2 instances, and in fact we have 4 of the stalking. It certainly caused reasonable emotional distress without a legitimate purpose, and the appellee requests that the court affirm.
Thank you.
Thank you.
A whopping 3 minutes and 22 seconds to rebut everything she just said.
I will do my best to rush. The first one that I want to address is Ms. Hewell keeps saying reasonable emotional distress, and that's not the standard. It has to be substantial emotional distress, that of a reasonable person. Additionally,
Where the trial judge hears all the testimony, does the trial judge essentially become this reasonable person to see if the trial judge would be offended by that, or fear, or any of the other?
the case law isn't clear on that. That is just the standard that the trial judge should be using. Our argument is the trial judge did not use that standard. He saw that she was in emotional distress and used the subjective person standard by specifically stating, I can see she's in emotional distress.
But the fact that the mother was also distressed, I mean, I think the appellee makes a good argument that you look at this person, then the other person who's aware is also distressed, and me as the trial judge, by entering the order, does the trial judge go, if it were me, I'd be upset as well?
It should have been, but again, I think it's because they use that subjective standard and not a reasonable.
That's interesting. Did the trial court, where in the record does it indicate the trial court used the incorrect standard?
He doesn't specifically state, but our argument was the trial judge had made a comment of basically saying that I don't know what you can say or do for me not to enter the injunction, and then our argument was it doesn't meet the requirement of one of them being substantial emotional distress of a reasonable
Said that
person.
pretty early on, right? Before you had a chance to cross-examine even the first witness.
That is correct.
He said,
That is
You're wasting your
correct.
time because I'm entering this injunction anyway, pretty much.
Yes, he said that very early on before all the evidence and testimony was presented, which is another issue that we don't think the right standard was applied, because his response to that was, I can see she's in emotional distress. And our interpretation of that is a subjective and not a reasonable person. Additionally, to that, opposing counsel was referencing the malice interpretation and that it was ill-willed because Ms. ZEEFF had kept contacting her after being requested not to. In Ravitch, a 5th District Court opinion, the trial court had said there was malicious intent because the petitioner had stated, don't contact me. Respondent kept contacting her. The appellate court actually overturned that because they said, based on the messages, there was no threat, it was not hostile, it was not abusive, so there was not a malicious intent behind those. Additionally, they had stated—
You take a statement to say, don't ever threaten me with a restraining order. Wouldn't you take that as threatening if somebody said, don't you ever do that to me? Wouldn't you take that as threatening?
I think based on the context of everything, because they are family, I think any reasonable person would be upset if someone said, hey, I'm going to file a restraining order against—
So would an ex-boyfriend or an ex-girlfriend or anybody else would be upset.
And even then, that's one message, and there has to be at least 2 that cause substantial emotional distress and serve no legitimate purpose.
So would you agree that that one is good enough?
No, I do not, but I'm just saying, in assuming arguendo that it's still not enough to meet the statute of there has to be at least 2 requirements.
Counsel, I didn't hear the testimony, so it's, I don't know that I can fully evaluate it, but when I read the messages, it seems to me that they could be read as quite condescending. Do you agree with that?
I do not, Your Honor.
Do you think there's no reading of these messages that could be read as substantially condescending?
Based on the testimony from my client and the reasoning that she gave, no, because she did not have any ill will in sending the messages as she wanted to try to amend that relationship, because prior to August of 2016, they had a relationship.
All right, your time has expired. Thank you. We'll be
Thank
in
you.
recess.